Welcome, everybody. My name is Alexandra Havrylyshyn. I am a staff attorney at Legal Assistance for Seniors, where I focus on housing issues. And prior to that, I was an education developer at the Judicial Council of California, where, among other things, I assisted in developing material for self-represented litigants on the Judicial Council's new self-help website, which we'll be looking at today. In my spare time, I enjoy swimming and singing in the Ukrainian Choir of California. So to tell you a little bit about LAS, or Legal Assistance for Seniors, we assist, in our housing practice, we assist tenants who are aged 60 and older. We do have a relationship with Adult Protective Services in the county, and we may assist dependent adults under 60 if they are referred to us by APS. We focus on issues such as, we help tenants with issues such as rent increases, Section 8 issues, habitability, reasonable accommodation, and we recently also started assisting pro per litigants in filing answers to their to summons and complaints for unlawful detainer. We do refer out for things like affirmative cases, forcible detainer, neighbor-neighbor disputes, and then some other practice areas where we help older adults are conservatorship, guardianship, public benefits appeals, naturalization, and we also recently opened a small claims practice, which does now especially have some overlap with housing issues. And just to put a plug out there, we are currently hiring another housing attorney who will focus on legal issues related to home-based community services. And Legal Assistance for Seniors houses the HICAP program, or Health Insurance Counseling and Advocacy Program, which each state and each county in the US has. It's a federally funded Medicare counseling program. So for today's training, I welcome your questions throughout. Some ways that you can participate if you wish. You can raise your hand by pressing here. I will be monitoring hands to see if there are any questions. So please stop me if there's anything, that occurs to you or that I can clear up in the moment. I will also be monitoring chat, so you can click here to open the chat and you can choose who to send your message to. And then finally, if you'd like to put your camera on so I can see your faces and reactions, I welcome that, but I also understand you might not be in an environment where you can do that right now. Oh, and finally, I am sharing this PowerPoint. You can choose your view, so you can go in full screen view and drag and choose how big you want, me or the other participants to be versus the PowerPoint. So that's a little about me. Now, I'd like to get to know you a little bit. So we will start with or I will launch a poll. And the question is, what best describes your relationship to landlord-tenant law? And I'll keep that up for about another 10 seconds. And I will share the results. So it looks like we have primarily either tenants or tenants attorneys and advocates. We do have some landlords, attorneys, or advocates, and other category. So I'm glad I put that other category in there. Okay. And another thing that one learning outcome, as you hopefully saw on the course description that was circulated and is the reason you signed up for today's training, is I hope that as a result of today's training, you'll be able to better identify some publicly available self-help resources regarding eviction. And since these are self-help resources, well, the first one we're going to look at anyway is relevant to both landlords and tenants. So my next poll question is whether you have ever used the self-help guide to the California courts online. This is a website. And I'll keep that up for another 5 seconds. And it looks like we are pretty much split down the middle. So about half of you have used this website and the other half approximately have not. So I will pull that website up now and share it on my screen. This is what the website looks like. As you can see, it's a self-help guide to the California courts, where this is the landing page, homepage. Litigants, there was a lot of work done at the Judicial Council to make sure that litigants on either side of any kind of dispute, civil disputes specifically, this doesn't address criminal disputes, on either side of a dispute would have information on the same topic. So, of course, since this is publicly available and not tailored to a litigant's case, it's not legal advice, but there is a lot of explanation. It's a great educational resource, and it can really help fill the gap for people who are not able to afford attorneys or maybe only able to afford attorneys for a part of their case. There are different ways to navigate the website. The litigant can choose their form. For some reason, it doesn't actually have the UD forms. I guess this is a website that's still in development, so it's highly developed on the family law side. Litigants can choose a topic, and actually here what I'll do is I'll give you a moment to explore the website and I'm putting the link in the chat now, with 2 questions in mind. One, if you're a landlord and you want to start an eviction lawsuit, how would you navigate this website? What pages would you go on to get information and resources? And 2, if you're a tenant and you've received a summons and complaint for unlawful detainer, how would you navigate the website? What pages would you point to? And also, what questions do you still have? So I'll give you about 5 minutes to yourselves to explore. And as you're finding answers, feel free to, either put in the chat what you're finding that would be useful to you yourself or to your clients. And then we'll do a little debrief if anyone wants to volunteer and share thoughts and resources. So hopefully that was enough time to explore a little bit. I do see one question in the chat from Madison, who noticed that although there are resources for tenants on what to do if they get a summons and complaint, they're not seeing resources about illegal lockouts. That is a good question. I'm going to just type here and see. Yeah, it doesn't look like there's anything regarding illegal lockouts. That could be a good thing to suggest to be added because although it's not, legally part of the eviction process, it is something that tenants encounter. So good catch. Jim says that in terms of helpful resources, so going to start a court case. So here, under start a court case for this audience, I think the most relevant one would be eviction. So let's just go there together. So this is an overview of eviction that will actually, the next step in this training is that we'll go through, these 6 steps of what to expect in an eviction process, which can be really complicated, and it can be really hard to break a complicated process down into just 6 steps while still being accurate. But the tenants I have worked with have said that this has been a really helpful way to think about it. And then Jim also says that get information about a legal topic seems to contain some excellent information. So again, let's go to eviction and housing. And this is actually the same information as what you would find under start a court case, but it's just presented in a slightly different way, which I find is helpful because, oh, I can enlarge the screen. Sure. Thank you for the comment. Antoinette, is that good? I'm not hearing a response, so I'll take that. Yes, it looks like it is. So this will lead us back to the get information about a topic, so an overview of the eviction process. Like I said, since it is a self-help resource, it is created by the Judicial Council or the judicial branch. It does have overviews for both landlords and tenants because the courts must be neutral. So this is kind of a sense of what the overview looks like for the landlords. So the focus is on how do you start a case? How do you ask for a trial date or default judgment? And then over here for tenants, it's this, the same information, but presented from the point of view of the tenants. So starting with, the notice, getting the notice. What does the notice mean? How, if at all, to respond to it. Of course, it's not legal advice, but it does give the tenant options on what they could do in their situation. Then, it has a step on how to respond to the court. So there is a section on COVID-19 eviction laws, more resources, as well as all of the forms, common eviction forms used in an eviction case. I do see a question in the chat. Will we get a copy of this presentation? Yes, happy to send. Well, the presentation is actually being recorded and will be on Alameda Law Library's website. And then I do have also handouts that accompany the presentation. Okay. Any other thoughts on what you found useful, or maybe what you don't see on here? What questions a landlord or tenant might still have? I mean, I know you've only had a few moments to peruse, but anything else pop out to people? Okay, so the handout that I will send you will have a link to this website. And now we'll move to what are these 6 steps that I mentioned? You can either, use this if you are a landlord or tenant, or if you're an advocate for either side. This can be a helpful way to explain what may happen. So we can think of step number 1 as notice. A landlord must give a tenant written notice to do something by a deadline. So for example, the notice might say fix a problem or move out, either fix the problem or move out by a certain date. The problem might be paying rent or not having paid rent. So notice to pay or quit is one possible title of the notice stated in the alternative. Notice of a lease violation. So this might be something like breaking house rules or cluttering the home to the point where it violates health and safety. Or it can be called a notice to terminate tenancy that is not any alleged fault of the tenant, such as an owner move-in or a need for the landlord to take the unit off the rental market in order to do substantial rehabilitation. So it's at this point, legal assistance for seniors does assist tenants with, we will review if the tenant is 60 or over, and of course we have capacity. We can help the senior review the notice, help them understand whether it's valid, and explain to them what, if anything, they can or must do before this deadline. And one thing that's really important that we tell all potential callers is that we do need to see a copy of the notice and the lease in order to assist the tenant. The second step is the landlord starts an eviction case in court. If the tenant doesn't do what the notice says by the deadline, the landlord can file an eviction case called an unlawful detainer. At this point, the landlord must give the tenant a written copy of the summons and complaint for unlawful detainer that they have filed with the court. One thing that many tenants don't know is that an notice by email or text that just tells them that they're being evicted is not lawful notice, and the tenant cannot legally be evicted on that grounds. As soon as the tenant receives a summons and complaint for unlawful detainer, they only have 5 days to respond in court. Otherwise, the judge will automatically rule in the landlord's favor. There are ways to put that aside, but we still always advise tenants to call us or another organization as soon as possible once they've received a summons and complaint. We are assisting pro per only at Legal Assistance for Seniors, and some of our partner organizations, I think some of which may be on this call, are also quite busy assisting tenants at this stage. So another self-help resource that is useful to know about, if you don't already, is the Tenant Power Toolkit. And I'll share that screen, I'm pulling that up now. And while I'm pulling that up, Zach, I see you have a question. Legal Assistance for Seniors serves tenants who are seniors in Alameda County only, not San Francisco or the South Bay. I do know San Francisco has an organization called Legal Assistance to the Elderly, which does assist senior tenants. So this is if you are a tenant and you are comfortable using online resources, or if you're a tenant's advocate and you have callers who are comfortable using online resources. This is a website that has been interactive website that's been developed to help tenants prepare their answer, since it is so crucial to file a written answer with the court. So the Tenant Power Toolkit has a list of questions that it goes through to help the tenant figure out how to fill these forms out and what potential defenses they might have. That's a good question, Nicole and Susan. As I'm reading it, I think it's the same question. I'm not sure if there are forms for that situation. Does anybody else on the call happen to know? Richard.
Well, the court clerk should have seen whether there's an answer filed. Not permitted the landlord to file that. So there's some mess up. And if Nicole is asking that the clerk is messed up, then there's a form to set aside default. Set aside default, but she should tenant file default. Yes. If she didn't double check with the clerk first and see if they had some error, and then after that you don't get a proper response, you can file a set aside default, motion to set aside default, and vacate judgment if it's gotten that far.
Thank you. Sorry. So as I mentioned, the tenant has 5 days to respond in court. Eviction cases can move very quickly, and it can be scary to get an eviction notice. So, it can take some time to find help, and hopefully some of these resources will help tenants who are not represented get the information and support that they need in order to meet that deadline. Of course, this excludes weekends and court holidays. And it's very important to get those potential defenses on the record in the answer. As well as serve the landlord or have someone who's over 18 and not a party to the case give a copy of the answer to the landlord, as well as filing it with the court. After that, you can try to reach an agreement with the landlord in order to avoid trial. So the court will schedule a mandatory settlement conference, and this could look like adding new terms to the tenancy, a probationary period, or an agreement that the tenant will move out in exchange for money from the landlord. After that, the court will make a decision. Either a judge or jury will make the decision. And the landlord will usually ask for a bench trial where the judge decides the case. The tenant has 10 days to ask the court for a jury trial instead. And the Judicial Council also has some resources on what to expect at an eviction trial and just in general how to prepare for court, how to behave in court, and yeah, how to prepare for court, and things like even what papers to bring with you, how to address the judge. So these are not things that self-represented litigants necessarily know. After the trial, if the court decides that the tenant has to move, the sheriff will give a notice to vacate, which is a notice to move out of the tenant's home. This gives the tenant only 5 days to move out, although there are ways to extend that process and get the tenant more time. If the tenant doesn't move out by that time, then the sheriff will remove the tenant and lock the tenant out. In addition, the court might decide that the tenant will have to pay penalties, filing fees, or attorney's fees, but under the Alameda County eviction moratorium, the landlord has to collect back rent through a separate civil case. If the tenant has good reason, they can ask the sheriff for more time, the court for more time to move out. And the tenant can also appeal the case if they believe the judge didn't follow the law. If the judge decides that the tenant can stay, then they can stay in their home, but it is possible that the tenant will face an eviction again. Okay. So I see a question about if a Berkeley tenant gave the landlord notice of COVID-related reason for delayed payment of rent, and the landlord filed an unlawful detainer anyway, does the tenant have to prove notice was given, or does the tenant have to provide medical and financial documentation? My guess is that the tenant would have to provide the court with proof that they gave notice of delayed payment of rent for a COVID-related reason. Perhaps others on the call have some insight into this. And for settlement conferences, my understanding is that the court is working with Legal Access Alameda and other nonprofit agencies to provide assistance in settlement conferences. I'm not sure whether the tenant can make that request. My understanding is that those organizations are there the date of the mandatory settlement conferences. How likely is it that the tenant will be allowed by the judge to stay appeal during appeal of UD judgment? It's my understanding that the judge is bound by, the law tends towards giving a tenant more time if they have a good reason. So I think it's pretty case specific. And yes, a tenant, well, habitability issues are a defense to non-payment. And I believe the tenant can also cross-claim by a civil suit, but that would be an affirmative suit, which would be costly. So I'm not sure that that's available to very many tenants. Now, one of you in the questions already mentioned the moratoria phase outs. So as of today is actually the last day of the Berkeley moratorium. But we've been in pretty long period of an eviction moratorium, and it of course is a patchwork of laws. So for those of you who are not attorneys on the call, housing law is a complicated area that is governed both by federal, state, county, and even city laws. So Alameda County had an eviction-wide, a county-wide eviction moratorium until 60 days after the date that the governor declared there was no longer a public health emergency. But then each city can also pass all kinds of housing laws, including eviction moratoria. So another poll, just to kind of test the knowledge in the room, but of course this is an anonymous poll and you won't be graded, so just answer your best, true or false. Do an eviction moratorium releases tenants from the responsibility to pay rent? And while you're answering that question, I'll address Diana's question. Yeah, so San Francisco did actually pass an ordinance stating that any tenant facing an unlawful detainer action would receive free legal representation. They passed that in 2019 or even before then. However, I don't practice in San Francisco, but my understanding is that it was a budget contingent ordinance, and that although San Francisco is doing its best to treat unlawful detainer somewhat like criminal law, where people cannot afford an attorney will get an attorney, that has not completely been rolled out. Richard.
So in San Francisco, there's something called the Eviction Defense Collaborative, and they will at least help you with the answer. They may not represent you. They may help represent at the settlement conference, but there is a free legal help from Eviction Defense Collaborative.
And is that funded by the county of San Francisco?
Probably many sources of funding, and I would imagine the county is one of them.
Mm-hmm. Yeah, because I know that it was part of the access to civil justice kind of Shriver movement to pass this law that was, I think New York City, that is, had passed a similar law, and then shortly thereafter San Francisco did. But I wasn't sure, how much they've really gotten it off the ground in terms of making it similar to a public defender's office.
I agree with you. It's not similar to the public defender system yet.
Yeah. So regarding this poll, all of you answered it correctly, which is false. The reason I put it on here is because we did have several callers during the moratorium period under the impression that the eviction moratorium meant a release from the responsibility to ever pay rent. In fact, what it meant was that tenants couldn't be evicted for non-payment of rent during the moratorium period. But can still be liable through a small claims action for the amount due. And that's one of the reasons that Legal Assistance for Seniors recently hired a consumer law attorney who is assisting people in all kinds of small claims cases, including responding to helping tenants respond to landlord claims for rent due during the moratorium period. So the question about how long does a tenant have to worry about getting sued for unpaid rent caused from the moratorium? Well, the general civil law would on statute of limitations would be 4 years if the lease was written down, and 2 years if the lease was oral. And I have not heard of there being any, differences in this area. Oh, and thank you. Evelina sent me a message that addresses an earlier question. So the Berkeley City Council recently amended the COVID-19 eviction moratorium such that the tenant now has, if they were unable to pay, I think this was Susan's question from before, if the tenant had been unable to pay rent during the transition period of May 1st through August 31st because of COVID, the tenant now has 45 days or 5 days before an eviction trial to submit documentation, such as financial or medical, of the COVID-related impact. Okay. And then Susan's question, if a landlord files a small claims case against a tenant for unpaid rent during COVID, and there were reductions in services, does the tenant bring up the reductions in service? I mean, it seems to me that that would be a good defense to bring up in the small claims case. They could bring it up as an affirmative case depending on where they live before a rent board, such as, for example, Oakland has a rent adjustment program, and among other kinds of cases that they hear are reductions in services cases. And then I should have probably put this slide a little earlier, but just to sort of have the two distinctions out there broadly, bird's eye view, there are two kinds of evictions. At fault evictions, such as non-payment of rent or breaching the lease, some kind of nuisance or waste on the property. And then there are the no fault evictions, such as owner move-in, substantial rehabilitation. Ellis Act would also be on this list, so taking the property off the rental market for at least 3 years. And I guess, the reason it's important to understand those two distinctions is because the different eviction moratoria treat these two evictions differently, these two types of evictions differently. So many of you may already know, but until July 14th, and I do have the citations on the handout that that Stephen will circulate on my behalf after this training. Until July 14th in 2023, almost all evictions in Oakland were not allowed. Eviction notices could start July 15th. So we did see a big uptick in callers. And I think that our partner tenant side nonprofit organizations did too, starting around that time. Even after July 15th, though, a landlord cannot evict a tenant for rent that was unpaid during the moratorium period of March 24th, 2020 to April 29th, 2023. So there was a transition period during which almost all evictions were banned, with an exception for an imminent threat to health and safety, or units where the landlord shares the kitchen and bathroom with the tenant, among a couple other exceptions. Another important element of the newest amendment to the eviction moratorium ordinance, which is cited in the handout, is that until July 1st, 2023, Oakland has a rent cap of 3% on or 60% of CPI, whichever is lower, until July 1st, 2024. Sorry, that should say 2024 on that slide. And actually, they this slide is current as of the time that the most recent ordinance was written, but since that time, Oakland has done the calculations on CPI and actually found that the rent cap is the lower of the two, which is 60% of CPI, which is 2.5%. So landlord may increase the rent up to 2.5% without having to submit any kind of petition on a covered unit, but they cannot go higher than that. And if they do, the tenant has a claim that they can submit either to the Oakland Rent Adjustment Program or before a court as a defense or an affirmative suit. In Berkeley, and I do see the question, so I will make sure to get to those before the end of our time together. In Berkeley, this is the covered period. And during the transition period, so this is some of the questions earlier in the chat were stemming from, does the tenant have to provide proof? When does the tenant have to provide proof of financial hardship? The reason those questions are relevant is that during the transition period, as long as the tenant shows proof of financial hardship that is COVID related, and there's a list in the ordinance of what is understood to be COVID related, then they cannot be evicted for a non-payment during the covered period. And that remains the case even after the moratorium ends, which is actually today. They still cannot be evicted for the non-payment. The landlord has to pursue the case either in small claims or civil, but they are allowed to pursue it in small claims, even if it's over $10,000 in this case. And then tomorrow, September 1st, all just cause evictions can proceed. San Leandro, somewhat similar to Berkeley in that the tenant had to provide a form, actually, that the city of San Leandro had, as well as proof of COVID-related financial hardship in order to benefit from this ban on evictions for non-payment of rent through July 1st, 2023. And it looks like we are close to time, so I will make sure to read the various questions in the chat and address them. But before I do that, I wanted to put up this slide with Legal Assistance for Seniors phone number. So feel free to write it down if you are a tenant and think that you could benefit from our services. Our housing intake line, by the way, sorry I didn't write it there, is extension 344. We also do provide the Medicare counseling services. So I know that's not the focus of this presentation, but any opportunity we can take to let people know that we provide those services we like to just let people know that. Oh, okay. So that's an interesting question. Sign, I hope I'm pronouncing that correctly. How long does the tenant have to get any unpaid rent from the state or county? So I assume you're meaning here the emergency rental assistance program. Is that yes? It looks like yes. So there was actually some recent, there was a settlement. That rental assistance program was sued. It ended in settlement for the tenants with several, basically the argument against the emergency rental assistance program was that they were not using the funds responsibly and not following due process and letting tenants know why they were denied for emergency rental assistance program. And it does seem that many people were unjustly denied. I'm not sure on the timeline on that, but if you can stick around for a moment, I can pull up a website that has a summary of that lawsuit that could probably give you some indication towards that question. In terms of, yeah, so statute of limitation, and actually, so your question also addresses statute of limitations. The standard statute of limitations is 4 years if a contract was written, 2 years if it was oral. However, there are ways to get that told or paused and extended. And part of that, this recent settlement is that those deadlines were extended. So I don't know the deadline off the top of my head. It's pretty complex settlement, but I'll try to pull that up for you after I take a look at some of these other questions. And now I'm looking at BBQ's question. So this is a question about if a landlord violates the ordinance and has to pay a civil fine, who does that go to? Usually that goes to the county. And I think that's the same for, the city of Alameda also has civil penalties that can be levied on landlords who violate the ordinance. So it goes kind of, back into the public coffers. Yes, so there is an argument, and then this is a question about can a tenant bring an affirmative suit for late fees? And there is an argument at case law and also under state law that late fees on a rent payment due are liquidated damages, which means not actually reflective of the harm that the landlord incurred. So that is a potential affirmative suit that can be brought. The next question, we do not offer assistance to landlords. We are an organization that helps tenants only. We do not assist landlords with their housing issues, so we would not assist a landlord to buy a tenant out of a property. But if a tenant receives notice that a landlord has offered them a buyout, then they are welcome to call us and we can advise them if we have capacity for it at that time. That's an interesting question about how many unlawful detainer cases are settled. I don't actually have the statistics on that. I do know that just in general, most civil cases are settled and do not go to trial, maybe up to 90%. I think that the statement of, not 90% of unlawful detainer cases settled at the mandatory settlement conference was probably more true before the eviction moratorium. And now we are seeing that landlords are not wanting to settle. Of course, any judge in a busy department has an incentive to get cases settled rather than going to trial. Oh, yes, certainly. We do not, next question about substantial remodel. That would be an affirmative suit. So we do not practice in that area, but I would recommend calling the Alameda County Bar Association Lawyer Referral Service and asking for a private tenants attorney, because that is definitely a claim for a wrongful, it would be called a wrongful eviction if the tenant believes that there actually wasn't a need to substantially remodel and have the tenants evicted on that grounds. And then the question about a bill to any agency if you take on an indigent case as a volunteer prosecutor. I don't know. That's an interesting question. I'm not sure. Oh, Evelina, thank you so much for putting the rental assistance resources in the chat. And then the question, so the city of Alameda, Catherine, didn't have, and it didn't extend its eviction moratorium. So I didn't include that on the slide. Are those the rules that you were curious about? LaDonna, you're welcome to call us. As long as you're a senior in Alameda County and a tenant who resides in Alameda County, you're welcome to call us at the number that I put on the screen. I do see it's 1:01, so I want to end this promptly and respect everyone's time. But thank you so much for your time, attention, engagement, and questions. And if anyone has any questions I missed, I can stay on another couple minutes. Oh, and let me pull up the ERAP settlement information. So here is a press release about the Emergency Rental Assistance Program settlement, which does have an impact on how and when tenants who applied for emergency rental assistance but didn't receive it, how they'll receive it. And Susan, I'm not sure on the answer to your question, unfortunately. I think that, the judge would have to consider each motion in turn. Oh, that's an interesting question about the small claims form. Huh. I don't practice in small claims, but you are welcome to call 510-832-3040 and ask to speak with our small claims attorney.